So if you want to change your status to one of the following employment-based non-immigrant categories, and I'll break those down on the next slide, your prospective employer should file a Form I-129 petition for non-immigrant worker. This is for, the Form I-129 is if you want to change your status to another temporary visa that allows you to work. And you need to do that before your Form I-94 expires. The I-129 serves two purposes. One, it establishes that you will be performing the type of work covered by the new non-immigrant classification that you're going to be moving into, and it also establishes that you meet the requirements for changing your status. And it's very important, you cannot begin work in that new classification until you get an actual approval for USCIS on your status. So, the other speakers talked about the categories, and this is the breakdown of the various categories. You've got your E, your treaty traders, investors, employees of treaty traders and investors. You've got your family of the H1Bs, the H2As, that's the skilled or unskilled workers. You've got L1As or L1Bs, that's what I call the intra-company transferees, and multinational corporations moving their employees between countries. O1 and O2, those are aliens with extraordinary abilities. We've even got categories for athletes and entertainers, that's the Ps. Q1s, the international cultural exchange visitors, those are most likely the people that you see working at Disney World. You've got your religious workers, the R1s, and then you've got a special category for Canadians and Mexicans under the NAFTA agreement, the TNs. Very important, whatever category that you're going to be moving into, that you know the specific requirements and the limits, including the limits on the length of stay. For more information, you want to contact the employer who has offered you temporary employment or qualified immigration counsel. And I say this at every outreach I go to. It's probably, you guys don't need to hear this, but when we say qualified immigration counsel, I'm talking about attorneys, licensed in the practice of law. I know in some other countries, we run into this more with the family-based petitions, but in some countries, notarios are qualified legal representatives. Not in this country. You never want to go to some fly-by-night, notary public paralegal. You never want to get legal advice from them. Stay away from them. If you want to change your status to another non-immigrant category that is not employment-based, if you're changing between employment, for example, the F1 to one of the H categories, the employer is going to be filing a I-129 for you. However, there are situations, it's very rare and it's very hard, but it has happened. I have seen it. Say, for example, your period of study is ending. Don't quote me on this because it's probably 9 times out of 10 not going to happen. But say after your graduation, you don't intend to stay in America, but you want to reward yourself and you want to stay and have a vacation. Theoretically, you can change to a tourist visa from your student visa. I think I've seen it happen once in my career, but it's a way to go. If you want to do that, you're going to be filing a petition for yourself, or the application of the petition. It's a Form I-539 application to extend or change your non-immigrant status. Now, if your status expires, remember, F student visa holders may only stay up to 60 days after the completion of their study or any OPT optional practical training. Failure to depart on the required date has very serious consequences, so plan carefully that you do not overstay even 1 day. I mean, it seems kind of crazy. Oh, I'm overstaying 1 day. It's not a big deal. It will bring you tons of headache years on down the road if you try to get a green card or you try to come back to the country, if you can even come back to the country. Overstaying can negatively affect your ability to obtain other benefits or return to the United States. If you're applying for a change of status, USCIS recommends doing it at least 45 days before your current status ends. Now, if I'm eligible for a change of status and I file in time, I do everything that I'm supposed to do, will my application be approved? Not necessarily. A change in status is not automatic. USCIS looks at every situation on a case-by-case basis, your current status, the reasons you want to change status, and the reasons you didn't apply for this kind of visa before you first entered. It will then decide whether or not to grant your application. If it grants a change, it will also decide how long to extend your stay in the new status, and they're only going to grant a change of status for a reason that is consistent with the terms of the requested status, or where circumstances indicate a change is warranted. What happens if I file for a change of status on time, timely manner, but USCIS does not make a decision before my status ends, which happens quite a lot? You're out of status when your duration of stay ends. Generally, as a matter of discretion, USCIS is not going to do anything. They're going to defer any removal proceedings until